Good afternoon, everybody. Thank you for joining us for the study group's presentation today. We're going to be focusing on planning for the community spouse after the nursing home spouse is Medicaid eligible. And we have the amazing May-Lis Manley with I think, an incredible firm with the Landsman Group. Not only are they experts in this area, but Ms. Manley especially is very compassionate and understanding when I've had to call her for things. So I'm excited for her to be presenting to our group today. And Ms. Manley, I'll turn it over to you then. Please take it away. Oh, and actually, one more thing about questions. If you have questions during the presentation, if you want to put them in the chat box, I'll try to delicately throw them in so that way, Ms. Manley, you don't have to take a look at the chat box while you're presenting, or save them for the end as well if you'd like.
Very good. Thank you, Ricky. As
Absolutely.
Ricky just said, I'm May-Lis Manley with Landsman Law Group. And within planning for the community spouse after the nursing home spouse is Medicaid eligible, we'll be focusing on how to protect assets if the community spouse predeceases the nursing home spouse, and having the community spouse start thinking about Medicaid planning for themselves. So within this, I'll be talking about the nursing home spouse, who I refer to as NHS in my materials. Other places you may see this person referred to as the institutionalized spouse, but I prefer to use nursing home spouse, NHS. And I'll also be talking about the community spouse, who is the CS, who is the spouse not residing in the nursing home. So we're going to start with a brief, very, very brief refresher on Medicaid eligibility and not get bogged down into this part a whole lot, but you need to just understand the basics to understand why the planning later on is also important. So financial eligibility for Medicaid considers countable and non-countable resources. I call them resources. A lot of you probably think of these as assets, and resources is just the term we use in Medicaid. So there are two types of resources, countable and non-countable. Countable resources include bank accounts, any type of financial account, and the cash surrender value of life insurance policies. These are the two big areas generally. Non-countable resources generally are the marital home, if the community spouse is residing in it, real property, if it's rental property or jointly owned real property and the other owner refuses to sell it, and vehicles for transportation, not recreational vehicles. So to be financially eligible for Medicaid long-term care benefits, Medicaid doesn't care how the countable resources are titled. And that's what Medicaid is looking at here, the countable resources. They can be in the nursing home spouse's name alone, the community spouse's name alone, or jointly titled. And very often the lay community gets confused about this, because I will have adult children come to the office and say, well, we knew that my father, for example, would probably need Medicaid, so we moved all the assets into my mother's name to protect them. And I'm thinking, that's nice. It's not going to help with eligibility, but it'll ease things or make things a little easier later on, perhaps. So as long as the couple is within their required financial limits, which we call resource limits, then they meet the financial eligibility criteria for Medicaid. So Medicaid attributes and says the nursing home spouse can have no more than $2,500. That's an easy one. But at the time of eligibility, it doesn't matter whose name that $2,500 is in. Later it will, but when applying, it doesn't. And this is the part that gets a little more confusing for other people. How much is the community spouse allowed to keep? So simply put, it varies from couple to couple. What Medicaid does is say, take what we call snapshot one. On the first day of the month, that the nursing home spouse was admitted to the nursing home. How much did the couple have in countable resources? Then, to be eligible in the next month or subsequent months, they have to spend down that month, that amount, so that they have no more than half of what they had in countable resources, the bank accounts and life insurance, cash surrender value, on the first day of the month that the nursing home spouse entered the nursing home. But it's not quite that simple. The community spouse never has to go below $27,480, but can never have more than $137,400. These numbers change every year, so we're using 2022 figures. That said, let me just give you a little example. So what that means is, say the couple on the first day of the month that the nursing home spouse is admitted to the nursing home, so they have $400,000. Then of that $400,000 in countable resources, $2,500 is attributed to the nursing home spouse, and the community spouse cannot have more than $137,400. And you're probably thinking, but wait, half of it is $200,000. Yes, half is $200,000, but again, can never exceed $137,400 in 2022. I always leave a cushion when I'm advising clients. I would never bring it that close, because very often you find out that people forgot about a little bank account they had somewhere and haven't used for a while. But this is just a brief refresher. So those numbers matter, how much money they have. And at that time of eligibility, like I said, doesn't matter whose name the money is in. So the couple spends it down appropriately, and they submit a Medicaid application, and we fast forward. Medicaid issues a notice of eligibility. And the notice of eligibility usually includes the date of eligibility, the amount to pay the nursing home each month from the nursing home spouse's income. Community spouse always gets to keep their income, never has to be used to pay the nursing home. And then the notice of eligibility also includes a 90-day protective period. And the notice typically says you have 90 days or until this date to transfer assets out of or countable resources from the nursing home spouse to the community spouse, so that the nursing home spouse really truly has no more than $2,500 in their name. And at this point, we start saying, okay, the flexibility we got away with before at the time of application, where it didn't matter how the accounts were titled, that's changing. It is going to start mattering. So you have to start taking some action to move assets or accountable resources from the nursing home spouse to the community spouse. The good news for the community spouse at this point is that starting with the second month of the nursing home spouse's Medicaid eligibility, Medicaid no longer looks at the community spouse's countable resources. They just don't care anymore. So at this point, you might be thinking, whoa, just slow down a second. How does this go? So let's use an example. On January 1st of 2022, the nursing home spouse applies for Medicaid and requests a start date of January 1st. A few months pass, Medicaid processes the application, and on April 1st, issues a notice of eligibility that gives a January 1st start date and says, okay, now your 90-day protective period is starting. Nursing home spouse, you have to move assets to the community spouse so that come July 1st, when the protective period ends, the only accountable resources in the nursing home spouse's name will be less than $2,500. On July 1st, for the community spouse, this is a deadline where the community spouse can now safely transfer resources, be it money, a life estate deed without powers, to people other than the nursing home spouse, and it will not penalize the nursing home spouse. I think there's a bit of two different camps in this area of, can the nursing home spouse, can the community spouse transfer assets before the 90-day protected period is up? Some people say yes, some say no. I tend to wait until the 90-day protected period is up because it's just usually not worth risking it unless the community spouse has health issues himself. Before I mention that, on the second day of, or second month of Medicaid eligibility, Medicaid will no longer look at the community spouse's resource. So in our example, the nursing home spouse was determined eligible for Medicaid on January 1st. So the beginning of the second month, February 1st, Medicaid no longer looks at the community spouse's resources. So the community spouse can inherit $500,000, can win $20,000 at the scratch-off lottery. No problem. The nursing home spouse will continue on Medicaid as long as the community spouse puts these new funds in a financial account that does not have the nursing home spouse's name on it. And that's extremely important. So the actions to take before this 90-day protected period expires are: 1, remove the nursing home spouse's name from all financial accounts except one, the one that receives their monthly income, be it Social Security, civil service, OPM, if they work for the federal government, private or state pensions, and transfer anything in excess of $2,500, and I usually use $500 just to be safe. Transfer those excess funds to the community spouse, who then opens a bank account or financial account in the community spouse's name, and they can be moved over there. I'm just going to pause for 1 second here. Some people say, some people have 2 accounts. You don't have to have just 1 account for the nursing home spouse's income, but I've seen situations where people have 2 accounts because the nursing home spouse's Social Security might go into 1 account, and then his private pension might go into a different bank account. So they have the nursing home spouse's name on both of those accounts. And it just gets tricky because you have to be mindful that on the first moment of the first day of each month, the combined value of both those accounts must be below $2,500. I think it's easier just having 1 account. So another action to take is to transfer ownership of life insurance policies that have a cash surrender value to the community spouse, so that the community spouse is the owner. Or perhaps cash out the policies and transfer the funds to the community spouse. May even consider changing the beneficiary. If the nursing home spouse is the owner of the life insurance policy and the insured life is the nursing home spouse's and the community spouse is the beneficiary, consider, does the community spouse have sufficient assets that she doesn't need the life insurance proceeds in the future? There's a chance she may need Medicaid long-term care in the not too distant future. Perhaps they want to name adult children or somebody else as the beneficiary. And this is where we're starting to also consider planning for if the community spouse needs nursing home care in the future. And then another action step is to transfer ownership of the marital home and other real property, especially if it's rental property or property owned jointly with somebody else. transfer it to the community spouse's sole name. And you may be thinking, well, why do you have to transfer the marital home and the real property to the community spouse? It's a non-countable resource. So if it stays in both the nursing home spouse's name and the community spouse's name, it doesn't disrupt Medicaid for the nursing home spouse. There's absolutely no problem with that. You can do that. But consider, what if the community spouse predeceases the nursing home spouse and the marital home or rental property is owned up by tenants as tenants by the entireties? Now the nursing home spouse is the sole owner of those properties. So yes, Medicaid still continues for the nursing home spouse, but Medicaid could put a lien on the real property, and or when the nursing home spouse dies, Medicaid also could file a probate claim against the nursing home spouse's probate estate. So while in the short term, there's no problem, in the long run, you're not protecting this property. So we want to be mindful of not only getting Medicaid eligibility now, but what can we do to protect and preserve some of those assets in the future? And if the real property, so let's say that our client follows our advice, transfers the marital home into the community spouse's sole name. The benefit of this is that Medicaid cannot put a lien on it. Medicaid also cannot file a claim against the community spouse's estate for benefits it paid to the nursing home spouse. Now, if at some point the community spouse applies for Medicaid and is receiving Medicaid benefits, then Medicaid could put a lien on the house, could file a claim against the community spouse's estate for the value of the Medicaid benefits paid on behalf of the community spouse. So we're going to talk about how to protect against that in a minute also. So at this point, you may be thinking, wait, what if the nursing home spouse has dementia? And that's one of the reasons they're in the nursing home. How do you affect these transfers? Who has authority to make these transfers? So we start with, well, does the nursing home spouse have the mental capacity to make these transfers? If yes, the nursing home spouse can sign a deed, nursing home spouse can sign the financial documents or the life insurance transfer papers to affect these transfers. If the nursing home spouse does not have the mental capacity, then you ask, does the nursing home spouse have a power of attorney that authorizes gifts or transfers to the community spouse? Just having a power of attorney in and of itself is not sufficient. If the nursing home spouse does not, then the community spouse must petition the court for a specific transaction guardianship or for a full guardianship of the property. If they're petitioning for a full guardianship of the property, the court order must specifically authorize the transfers to the community spouse. The community spouse cannot just be guardian and transfer assets to herself. My understanding is that in Prince George's County, if you're transferring more than one item, say it's a financial account and it's real property, the marital home, that the court requires you to get full guardianship. I know in Montgomery County, that's not necessary. We can kind of give a laundry list of items we want transferred and do it through a specific transaction. So just to be aware of that. If that is going to take more than 90 days, write a letter to the Medicaid caseworker, letting them know that you've started the process, you're petitioning the court, and you request an extension. We've never had that be denied. And usually, well, again, I work in Montgomery County, so usually that's not a problem. So Now we fast forward a little. The transfers are made, the 90-day protected period expires. At this point, I advise the community spouse to seriously consider conveying the marital home to any children they have. If they have a good relationship with their children and that is their estate plan to leave the house to their children equally. And we say, and let's consider transferring the house to the children and retaining a life estate without powers for the community spouse. This protects the home in the event the community spouse needs Medicaid in the future, and it protects it from Medicaid putting a lien on or from estate recovery, because the home will never go into the community spouse's probate estate. It will pass directly then through the life estate deed to the children. And with the life estate deed, the children also get the step up in basis, so they're not sacrificing anything along the tax lines. Let's say the community spouse does this, signs a life estate deed, and then within 5 years, because now the community spouse has done a transfer, does not affect the nursing home spouse at all, but it may affect the community spouse if the community spouse needs Medicaid within 5 years. Because Medicaid has a 5-year look back and says, did you make any transfers or gifts, anything for less giving away something for less than fair market value within the past 5 years? If so, then Medicaid will penalize the individual and say, you don't get Medicaid for a specific number of months based on the value of the gift or transfer for less than fair market value. Well, if the community spouse has followed our advice, and which we're going to talk about in a few minutes, has signed a new power of attorney, that her or his agent should now have the flexibility to decide what actions to take. Should they undo the life estate without powers? Or if they're very close to hitting that 5-year mark, the 5-year look back, maybe they just don't apply for Medicaid yet. Wait until 5 years and 1 month, apply for Medicaid then. But the new power of attorney provides flexibility for the agent to decide how to handle that. Another planning tool for the community spouse is to execute a new will that specifically gives the nursing home spouse's spousal share to a special needs trust in the will for the nursing home spouse. Whether or not this is titled a special needs trust is not so important. What is important is that the trust is in the will, not in a revocable living trust. And it has to be a discretionary, non-support, irrevocable trust without Medicaid payback. That's the whole advantage of doing this, is that there won't be any Medicaid payback. The community spouse gets to determine who will be the trustee and who will be the remainder beneficiaries, so that whatever passes into this special needs trust, the trustee can use it. The trustee has discretion to decide whether or not to use some of those funds for the nursing home spouse. If the nursing home spouse needs something extra, perhaps a geriatric care manager or a visitor once or twice a week, the funds can be used for that. Otherwise, the funds just remain in that special needs trust. And when the nursing home spouse passes, then those funds will be passed on to the remainder beneficiaries. And again, I stress the advantage of this is there is no Medicaid payback. So you may be thinking, well, why doesn't the community spouse just simply disinherit the nursing home spouse? We used to do that. We used to tell the community spouse, let's make sure nothing passes through your probate estate. Let's have it all passed by beneficiary designations, by life estate deed, by payable on death accounts. And the reason for this is because Medicaid requires the nursing home spouse to receive all property to which they are entitled. Well, our planning changed a couple, I believe it was 1 or 2 years ago, when the augmented estate came into being. So now, if the nursing home, the community spouse predeceases the nursing home spouse, the nursing home spouse must elect their spousal share. And now their spousal share will be not only what is in the probate estate, but it includes everything else that passes by beneficiary designation, that passes by life estate deeds or other type of deeds. So we have a much bigger pot for the nursing home spouse to take their elective share. You may also be thinking, well, just disclaim. Why doesn't the nursing home spouse disclaim? And as I said, Medicaid penalizes disclaimers because the nursing home spouse must take whatever they are legally entitled to. So a disclaimer won't work in this situation. I want to point out that the right of election can only be made by the surviving spouse, by a guardian of the property, or by an agent under a power of attorney. And for the guardian and agent, the documents must specifically authorize them to make the election. It cannot just be a general power. So when you're preparing your powers of attorney, take into that into consideration also. So in our wills, we add specific language talking about the statutory share, saying that if the nursing home spouse elects the spousal share, then it's going directly to the special needs trust that we're setting up in the next article in our will. And this is important. Well, what would happen if the community spouse does not have a will with the statutory language in the special needs trust? Well, if the nursing home spouse takes their inheritance outright as cash, there are funds there. Depending on the value of those funds, they might just have to pay some of it to the nursing home as part of their patient pay amount, or they could actually end up losing Medicaid if they put the funds into their bank account and don't spend down, and they end up having more than $2,500 a month after they receive it in their bank account. An alternative is the nursing home spouse could irrevocably assign the inherited funds into a first-party special needs trust or a pooled special needs trust account, depending on the age of the nursing home spouse. In this situation, the nursing home spouse would continue on Medicaid, but the funds that remain in that account, in the special needs trust or pooled special needs trust, when the nursing home spouse dies, are subject to Medicaid payback. So it's kind of like you got to use it while you're living or you lose it. Again, not the best of all plans. If the nursing home spouse inherits the marital home, for example, now the home is subject to a Medicaid lien, and it also is subject to estate recovery, a claim against the nursing home spouse's probate estate. Depending on the value of what the nursing home spouse received, they may decide to do something called a gift in return, but I am not getting into that today. That's a whole nother story. So other actions that the community spouse should take are check their beneficiary designations and change the beneficiary designations to somebody other than the nursing home spouse. Name their children, for example. Why to do this? Again, we want to decrease the funds that may pass to the nursing home spouse because we want the nursing home spouse to not receive excess income and to not receive excess countable resources. Another step the community spouse should take is to execute a new power of attorney. And we always recommend that the power of attorney give the agent authority to establish and fund an irrevocable trust. So this would include a special needs trust, a pooled special needs trust account, for the community spouse themselves, or for others, and include the authority for your agent to make gifts outright or in trust to family members, including the agent. This again is for future planning in case the community spouse needs Medicaid in the future, and you have to do some type of gift in return or some other type of transfer there. And this, even if you don't end up needing it, it provides flexibility for the agent to be able to plan better for the principal. So other planning for the community spouse would be to consider taking into account Medicaid's 5-year look back. Does the community spouse want to establish and fund an irrevocable 5-year trust and move their assets into this? Again, you could do a whole program on the irrevocable 5-year trust, but basically it protects those funds as long as the community spouse does not need Medicaid within 5 years of the funding of the trust. And the difficult part for many people, though, is the community spouse is giving up control. The community spouse is not the trustee, somebody else would be the trustee. So that's difficult for somebody, and it's a huge consideration. Another alternative to Medicaid long-term care for individuals who do not have long-term care insurance would be something like a continuing care at home program. Jason Frank asked me to mention this, and I believe that Ricky put more information about this program in the chat box. But basically, the continuing care at home program allows people to stay at home and be able to have caregivers come into their home. This program acts like a long-term care insurance in the sense that it pays a certain amount daily for caregivers to come into the home. An individual, when they sign up for this, they pay an entrance fee just like they would at a continuing care retirement community. And they do pay monthly fees. Jason said it's believed that Medicaid will treat the entrance fee as an appropriate spend down because the individual is getting fair market value for their payment. And he also said that the Wesley at Home program is a new program that will be offering services to members beginning July 1st, 2022 in Baltimore City and County. My understanding is this is the first CCAH in Maryland. And then they're looking to seek to offer services throughout the state later this year. I don't have any more information on that. That would be something you'd want to talk to Jason Frank or the Wesley at Home program.
And I just put the document in the chat box that you just mentioned.
Thank you, Ricky.
Yep, and I think I have one question that someone just put in the chat box. If you want me to share that with you.
Sure.
When making transfers using a deed with life estate, if there is a mortgage on the property, won't that create a problem for the bank? Also, will this alter the rate of property taxes? If there's a senior discount, would that be lost?
So the first question is perhaps. And we always advise our clients that it is possible that the mortgage company, the lender, could call the note. We have never had that happen as long as you keep paying the mortgage. Our experience is that the mortgage company just hasn't cared. And we typically do not notify the mortgage company before doing this because we don't want any problems, but we advise the client, keep paying that mortgage. The second question is, yes, it could affect any senior discount on real property taxes. And I will say, with taxes and Medicaid, they don't dovetail a lot. You got to pick your poison at the time, and which is more important, So getting to the next question, doesn't this disrupt the marital couple's previous estate plan? Sure, absolutely. But with Medicaid, it's a new game and we're not playing by the old rules. So you have to look at what else you can do. Another question that may arise is if somebody says, well, I've heard about the SAFE Act, the Maryland statute against financial exploitation that was enacted, I believe it was October 1st of last year. Shouldn't the community spouse be concerned about a civil suit for financial exploitation in a situation like this? And the answer is no. The SAFE Act specifically exempts legitimate Medicaid planning in protecting and preserving assets for an identified person. And in this case, the identified person would be the community spouse. So that is not a concern. At the end, I have a checklist of a long, not a brief checklist of steps to take or at least consider. And these are what we just discussed. And that is my presentation. If anybody has any questions, I will say, I do know there is not a lot to do. It's not a long checklist. However, these few things can protect significant assets of value. So they're worth considering, they're definitely worth doing, depending on what your client wants. And again, it's not a lot, but they're very important. So if anybody has any other questions. And Wendy put in the chat box, as you all see, that on Monday, April 29th, Jason Frank will be presenting on the Wesley program through the Elder Law Section Council's Lunch and Learn.
Excellent. Thank you, Wendy. It looks like we have another question.
And
Can you explain the difference between a life estate deed with powers versus without?
yes. So a life estate deed with powers gives the owner of the home the right to sell the home and receive all those proceeds. Life estate deed without powers, the owner cannot, or the I'm blanking on the term. We'll just say the owner, for the sake of this, cannot sell the property unless they obtain the consent of the remainder beneficiaries. So again, with the life estate deed without powers, the community spouse is, in this case, is giving up control. However, Medicaid treats a life estate deed without powers differently than it treats a life estate deed with powers. And again, I feel like that we could be here for 15, 20 minutes on that. So I'm just going to leave it at that and say the way Medicaid treats them is differently.
Excellent. And also we have another question. You indicated that the community spouse should add an S&T to his or her will and not in his or her revocable trust. Could you please clarify?
Yes. So federal law requires, but I could not for the life of me find the site. Federal law requires that the community spouse state in their will that and have the special needs trust in their will, that it's not sufficient to have a pour over will and then have the spousal elective share language and the special needs trust in the revocable living trust. You must have it in the will. And I'm sorry, I couldn't find the site for that, but it was right after COVID hit. We had that situation arise and we were spent many hours looking for that. And that was our conclusion. It must be stated in the community spouse's will.
Excellent. Does anyone have any other questions? Oh, here's another one. Okay. How does the transfer of title from the community spouse to the children impact the capital gains tax basis on the property?
I am not a tax person. I do Medicaid, so I don't know. I can tell you though that a life estate, be it a life estate without powers or a life estate with powers, does get the step up in basis.
And like you said earlier, often the tax, rules are opposite of the Medicaid rules. So you have to almost give up one to get the other usually.
Right.
One of the attendees said that carryover basis if no powers. Thank you, Stacy, for sharing that.
Thank you, Stacy.
And then will the slides be available, Ms. Manley? Will you be able to share that with
Sure.
us? Excellent.
Sure, as long as Angela would be the one who would take care of
Excellent.
that.
Yeah,
Absolutely.
we'll get that sent out to everybody. And then if you have any other questions, is your contact information in the slide as well?
It is. It's on the
Excellent.
second slide. So please feel free to email or give me a call.
Wonderful.
I'd be glad to help.
Thank you for making this, very easy to understand. And again, it was a lot of things that kind of makes it, realize that we all can help, even especially the spouse in that kind of situation to protect even more for them and for the children. So it's really important for us as planners to keep that in mind.
That
So
is
thank you so much.
as you just said, Ricky, very often I feel like people get to the point where they've got the Medicaid in place and you just can't stop there. As they kind of say, it ain't over till it's over, because everything could really switch quickly if the community spouse dies first. And just to point out, we actually did have that happen several years back. I want to say like 10 to 15 years ago. The community spouse was in excellent health and died in a car accident. And yeah, we have to do some quick maneuvering.
And often to have backups as well, right? In general, you always have to put
Exactly.
someone the Mack truck theory.
Yes. You got it,
Excellent.
Ricky.
Thank you so much for a wonderful presentation. I hope everybody enjoys the rest of their afternoon, and we look forward to seeing you next month. Thank you all so much.